Hi, all. My name is Jessica Brewer, and I am a staff attorney with the New York County Lawyers Association. We run the Volunteer Lawyer for the Day program in New York County, where we provide legal assistance in a variety of ways to litigants who have cases pending in the New York County Civil Court in the consumer debt part. This presentation is intended to provide legal information, not legal advice, on the topic of understanding judgments. If you have a case in New York County, you should reach out to us to see how we may assist you in your upcoming case. So let's talk about judgments, what they are, how they happen, and what happens next. First of all, what is a judgment? A judgment is paperwork filed in the court that states that a debtor owes a certain amount of money. Or put in a different way, a judgment is a court order that is the decision of a lawsuit. If a judgment is entered against you, a debt collector will have stronger tools, like garnishment, to collect the debt, but we will discuss that more in depth later on in the presentation. So how does a judgment happen? When a plaintiff files a lawsuit against you, it doesn't mean that there's automatically a judgment entered. Instead, a lawsuit is a plaintiff asking the court to rule that the debtor is liable for the amount they are being sued for. To ask the court for this, a plaintiff must file and serve a summons and complaint. If and only if the court rules that the debtor is liable, then the plaintiff can file the paperwork with the clerk entering the judgment against the debtor. A plaintiff can do this in a few ways. First, through the entirety of the court process, meaning they either won their case at trial or they moved for summary judgment and the court granted their motion. Two, through a default judgment. If the debtor fails to appear in court, then the plaintiff can state that since the debtor did not appear, they are entitled to a judgment based on facts they only set forth in the complaint. Through an inquest clerk. If a debtor fails to appear and the plaintiff has not made a motion, they can request that an inquest clerk review the paperwork and enter judgment in the amount stated. Technically, this is also a form of default judgment. So let's circle back to option one and look more in depth at that process. To bring a lawsuit, a plaintiff must file a summons and complaint. Here is an example of a summons and complaint. You will see here where you are being sued, who is suing you, the amount you are being sued for, and the law firm representing the plaintiff. The defendant should receive this in one of a few ways. First, a process server should attempt to serve the defendant personally by giving them or a household member a copy of both the summons and complaint at their home. You should also be mailed a copy of both. Once you receive a copy this way, you have 20 days to appear at the courthouse to answer the complaint. If the process server attempts to serve you or a household member at home 3 times but can't reach you, then they are entitled to post the summons and complaint on your door as well as mail you a copy. Once you receive a copy this way, you have 30 days to appear at the courthouse to answer the complaint. Let's look at an example of an answer. It states defenses and answers as to why a debtor may not owe the debt. Assuming you received the summons and complaint and filed an answer, the court case will be put in front of a judge. You will receive notice of that date that you must appear in court when you answer. Once the plaintiff files and properly serves the summons and complaint and the debtor has answered, then the entire court process proceeds, and the plaintiff has the option to make a motion for summary judgment. A motion for summary judgment is a motion which states that there are no issues of fact, and therefore, based on the documentation and the evidence, the debtor is liable for the amount stated in the complaint. If the plaintiff proves the case in the papers, then they may enter a judgment. If they do not file a motion or they do not win their motion, then the case will go to trial, where the plaintiff will have to argue in front of a judge why they should win. If they win, they receive the right to enter a judgment. Default judgment. If you fail to appear after the summons and complaint are served, the creditor may make what is called a motion for default against you. This means that they are asking the court to rule that you owe the amount they are suing you for without you ever stating your case. The creditor is allowed to do this if they show that they properly served you and that you did not come to court after service. If the court grants the motion for default, the plaintiff receives a default judgment against you. This means that even though you did not come to court, the court has ruled that you owe the money the creditor has claimed you owe. An inquest clerk. If you received the summons and complaint, filed your answer, and then did not appear in court, the court may order an inquest clerk marking. This is similar to a default judgment, meaning that the creditor is granted the ability to enter a judgment against the debtor without fully proving their case at trial. This can occur at any court appearance that a debtor fails to appear. So the creditor has a judgment against you. Now what? It is important to note that a judgment can be collected for up to 20 years. Unfortunately, this means that a creditor can have a judgment that collects 2% interest a year for 19 years and then begin the collection process. A creditor must take action to collect a judgment, meaning that it is not an automatic process that begins once a judgment is entered with the court. So how does the collection process work? A creditor will search for the debtor's assets, meaning bank account funds, property owned, or other tangible assets that a debtor may own. If a debtor has assets in a bank, then a creditor can restrain those funds. This is done via a marshal. What that means is that a marshal will contact the debtor's bank, and the bank will put a hold on the funds in the amount of the judgment, often plus extra for the marshal's fee. Once the bank releases the funds to the creditor, the debtor should receive a satisfaction of judgment, meaning they have paid what is owed and the case is officially satisfied. Importantly, the creditor cannot take any funds from an account that is only receiving exempt income, which we will discuss shortly. The bank may not restrain the account if there is less than $3,000 in the account, or $3,400 if the account contains some exempt income and some regular income. Another way the creditor may collect on a judgment is through a wage garnishment. The creditor will search for the debtor's employer, and if the debtor is employed, then their wages can be garnished. A wage garnishment occurs when a court orders a debtor's employer to set aside some of their earnings to pay a debt. The amount of the debtor's wages that can be garnished for a private debt varies according to income. Private debts include credit cards, medical bills, bank loans, private student loans. If the debtor's disposable income is $450 a week or less, then all of their earned income is exempt from debt collection. Their wages cannot be garnished. If the debtor's disposable income is more than $450 per week, the creditor may garnish up to 10% of the debtor's gross income or 25% of their disposable income for the week, whichever is less. However, the creditor may not reduce their weekly disposable income to less than $450 per week. If you are already being garnished for child support or spousal support, then you can still be garnished to pay a private debt, but the total garnishments cannot exceed 25% of your disposable income. Disposable income is the amount of money one takes home after deductions required by law, such as deductions for taxes, Social Security, and unemployment insurance. Gross income is the amount one earns before any deductions are made. Exemptions. If a debtor does not work, they may be exempt from the collection of a debt. What does this mean? There are certain types of income that are quote-unquote judgment-proof. It is important to note that this is a term of art, meaning there can still be a judgment against a debtor. The creditor may just be unable to collect the funds. How is this possible? Well, there are many forms of exempt income, meaning income that a creditor may not touch or collect when attempting to enforce a judgment. Enforcing a judgment means looking for money that a debtor has that a creditor is allowed to collect. The forms of exempt income are as follows: Social Security disability, supplemental security income, public assistance, wages earned under $450 while receiving supplemental security income or public assistance, veterans benefits, unemployment insurance, payments from pensions and retirement accounts, disability benefits, income earned in the last 60 days, 90% of which is exempt, child support, spousal support or maintenance, workers' compensation, railroad retirement benefits, or Black lung benefits. Any of these benefits cannot be collected if a creditor was to receive a judgment against a debtor. One last note. If a debtor is only receiving public assistance, it is not a defense to the debt, meaning that the debtor can still receive a judgment against one only receiving exempt income. However, the creditor will have no way to collect it. Thank you for listening and tuning into this topic. Please reach out if you have a case in the New York County Civil Court, Consumer Debt Part, and need assistance.